Hello everyone and welcome to my presentation. Today I'll be presenting on the Family Medical Leave Act of 1993 and my name is Kristen Wilson. The Family Medical Leave Act of 1993, also known as FMLA, entitles eligible employees of covered employers to take unpaid job-protected leave for specified family and medical reasons with continuation of group health insurance coverage under the same terms and conditions as if the employee had not taken leave. Eligible employees are entitled to 12 work weeks of leave within a 12-month period for the birth of a child, or to care for a newborn within 1 year of birth, or the placement with the employee of a child for adoption, foster care, and to care for the newly placed child within 1 year of placement, or to care for the employee's spouse, child, or parent who has a serious health condition. A serious health condition that makes the employee unable to perform the essential functions of his or her job, or any qualifying existing arising out of the fact that the employee's spouse, son, daughter, parent is a covered military member on duty on covered active duty, or 26 work weeks of leave during a single 12-month period to care for a covered service member with a serious injury or illness if the eligible employee is the service member's spouse, son, daughter, parent, or next of kin. The FMLA is to protect people, and there are an application process that you would have to do with your employer to if any one of these conditions you meet and wanted to take time off for those reasons. Why is the act necessary? Well, the FMLA has been a long time in the making, and it was to protect women of childbearing age on the job because prior to 1978, women were entering the workforce but had no protection when they became pregnant or had any sort of issue, I shouldn't say issue, relating to a pregnancy. She wasn't protected. Her job was not guaranteed, and a lot of women left the workforce to have children. So it originally was created to protect women's rights. One of the first steps, like I said, in making the act happen was in 1978 with the Pregnancy Discrimination Act. And this prohibits discrimination on the basis of pregnancy, childbirth, or related medical conditions. However, this particular act did not provide time off, and nor did it really protect the woman's job. Then from there were many early versions of what we now know as the Family Medical Leave Act. Early versions include the Family Employment Security Act in 1994. There was also the Parental Disability Act in 1995. And in 1996, legislation evolved to include medical leave, and the family medical leave was introduced in 1986. It spent 4 long years in Congress, and many changes were brought to light, like the addition of an employee to care for a spouse, child, or parent who are ill. That bill was passed in Congress in 1990. However, George W. Bush vetoed the bill when it came across his desk. As we know, though, the bill did not die because in 1993, Bill Clinton, as one of his first acts as president, he became president or was sworn into office in January, and I believe it was in February that he signed this bill into law. So he didn't wait for very long to take action. The bill has changed over the year. Language has been added. Some provisions have been made. Some of the changes that have been made is in 2009, the language related to leave for military members, military family members to care for those injured or sick. That was added to the Family Medical Leave Act. And then in 2020, we're all familiar with what happened in 2020. Those fun, the fun start to COVID. But in 2020, provisions were added by an executive order put in place by Donald Trump to protect those who were suffering from COVID, either the illness itself, or they lost childcare, or they had to care for a family member with COVID. So the act was expanded to include COVID. The bill truly moved from women to focusing on, as the name suggests, the family. This bill is about the family unit and protecting the family. Rulings are made all the time related to FMLA since its introduction in 1993. One of them is DePranto versus MWRA. In this particular case, which was ruled on in 2021, the employee went on medical leave for a foot ailment, and then they went to their employee later and said, "Can I come back early? I don't want to use all my time." The employer said no. And the reason why this employee wanted to come back was because they had a planned vacation. And since the employer said no, the employee went to Mexico on their last week of FMLA. The employer got wind of this and then fired the DePranto, and DePranto filed suit. And what the court decided, they decided in favor of DePranto, and the court decided that as long as the person taking FMLA is living under the restrictions of their medical leave, their approved medical leave, it does not matter where they are. So you don't have to sit in your home all day. The vacation was appropriate in this particular case. So, he couldn't have hiked the, Andes Mountains or something like that because that would have been outside of his medical leave condition. But if he's going to sit on a beach, he's relaxing, his foot's up, that is within his approved medical leave. The other case that came up recently is Kahara versus Priority. And in this particular case, the employee was granted a part-time family medical leave for a mental health condition. And the employer started receiving complaints about this employee because, she wasn't getting her work done. And so the employee was having a difficult time juggling a full-time workload on a part-time schedule. But the employer went to the employee and said, "Listen, you either need to return to the office full-time or go on leave full-time." And she did not. She chose to continue with what was approved, the part-time situation. And the employer ended up firing her. She filed suit, and the court ruled in her favor, stating that it was not within the employer's, they did not have the right to demand her to come back full-time or to take full-time when they originally granted her part-time. So they agreed that they should have provided some sort of work assistance to help her get her job done in the means in which that they approved the FMLA. Also relevant to the court cases, the government website has a great deal of information, and they have several attorney opinions written on different topics. Stephanie had posted on a discussion board about how her employer has a point system, and there's even a ruling out there by an attorney that addresses how point systems should be considered and during FMLA. So I thought that was pretty interesting. There's a lot of information out there. So if you're an employer or a person seeking to take FMLA, there's a lot of resources out there. So now in the future state of the Family Medical Leave Act, there have been many attempts to expand FMLA under every administration since it was put into law. So that's the Obama administration, the Trump administration, as well as currently now the Biden administration. There was quite a bit of language in his Build Back Better plan, which we all know, did not get passed. But some states, since the federal government has not expanded FMLA, some states some states have expanded coverage and allow for additional benefits. So, for example, there are 11 states with paid family medical leave, or excuse me, 11 states with paid family leave, and 16 states offer paid sick leave. So these state laws come alongside and kind of robust the federal law that's already out there. So it'll be interesting to see if the current administration or future administrations add to the benefits of the Family Medical Leave Act. These are the references I used for my presentation, and I hope you enjoyed it. Thank you.